Welcome to this session of oral argument under the 5th District Court of Appeals. It's certainly our pleasure to preside over the cases on the docket today. Let me introduce the panel to you. Again, I'm Judge Sawaya. Seated to my right is Judge Wendy Berger, and to my left is Judge Rand Wallace. We have two cases on the docket today. And we will call them in the order that they are presented. We've had one case where we've dispensed with oral, actually two, and one case has been continued. So we should begin with Hendricks versus Department of Business. If you have any electronic devices, please turn them off so that we're not interrupted during the course of the oral argument. We have a clock on the podium that will assist you in keeping time. If you have a problem with the clock, let me know, and I'll also try and assist you as well. So each side will have, since these are civil cases, 20 minutes per side. If the appellant wishes to reserve any time for rebuttal, let me know. So with that, we'll begin with Hendricks versus Department of Business.
May it please the court. I am Michael Pugh, and I represent the appellants in this case, and I would ask if I could reserve 5 minutes for rebuttal if it's necessary. I represent what is really the remnants of a tribe of people who started on a journey in 2004. There were almost 200 people that I represented at the time, and now I'm down to 12. And if the court would like, I can give some history as to why this case has happened this way, but we originally filed a case for these plaintiffs in the circuit court after getting default judgments against these particular defendants. Then some creditors of the identified seller in the contract pushed it into bankruptcy, and so we went through that course, and during the course of that bankruptcy, the bankruptcy judge entered a bar order. This isn't in the record, but it's backgrounding. In
well,
case
just
like
stick with what's in the record, so
yes,
that we don't go astray. So,
yes, sir.
And I think we're pretty much familiar with the facts and circumstances. So if you want to just get to your primary legal argument,
I'll be glad to do that.
all right.
As the court knows, our position is that perhaps the most important legal fact that is involved in the sale is whether or not the seller has title to that property. And the judgments in this case basically determined that these particular defendants that were involved in the Fret case knew or should have known that the identified seller in their contract did in fact not have title to the property that was being offered in the contract for sale, and did not inform our clients. The court entered a default judgment, and as we've argued in our briefs, a default judgment is in fact an admission.
Okay, the default judgment did not reference any fraud, is that correct?
It laid out the elements for fraud.
But it never mentioned the word fraud, correct?
No, sir, but it does say that they knew or should have known, and I've cited cases to the court, such as the Niani case, which identifies the elements for fraudulent inducement and for negligent misrepresentation. And those elements are, for fraudulent misrepresentation, a false statement concerning a material fact.
And what were the false statements that were made?
Well, a false statement may be an admission under the Johnson versus Davis line of cases, where you're dealing with residential property and you fail to provide information that can affect the value. And I can't think of anything that affects the value more to what you're willing to pay for a property than whether the seller owns title to it. And such an admission, the Supreme Court has found, is sufficient to state a fraudulent misrepresentation.
But was the fraud just was it a fraud by omission, or was there an actual affirmative statement made as far as who held title to the property?
It was fraud by omission.
Okay,
Yes,
so
sir.
basically silence was the fraud.
Yes, sir. The fact that they had knowledge and they didn't inform the sellers of that. And there is evidence in the record that such people as Mark Goldberg, Tracy Penny, Mr. Ambrose, Steve Ambrose, did in fact have knowledge with respect to the fact that Superior Homes did not own the property. So, for instance, Mr. Goldberg, who testified in the deposition that is in the record at Volume 9, testified that he was a sales manager, supervised all salespeople, and instructed them on how to do their job. And that can be found at pages 1639 through 1641. That everyone at Superior Homes was in sales. Again, that can be found at page 1633. That he supervised Mr. Penny and Mr. Ambrose, that he signed Mr. and Ms. Watkins' contract, and that can be found at page 1646 and 1647, that he knew Superior Homes did not own the property. You can find that at page 1639 and 1636 to 1637, that he saw practically everyone that walked in the door, hundreds of people, 1648 and 1645 to 46, but he never told anyone that Superior Homes or any of its affiliates did not own the property. And that can be found at page 1653. He even testified that after leaving Superior Homes, it was his practice in his new real estate position to always inform his purchasers who owned the property. He testified that after leaving Superior Homes, he always made sure that the proper owner was in the contract. You can find those statements at pages 1653 to 1654, and he said that, of course, salesmen got paid more if they sold property for Superior rather than the properties that it might show generally. Finally, he testified that he never intended to use his license. Now, here's what was alleged with respect to the contact with these particular defendants. What was alleged with respect to contact was that for Ms. Hendricks, who got a judgment against Myrna Ambrose, testified that her only contact was a tour of the property in March of 2004. For David and Gabriel Watkins, who got judgment against Mr. Penny, only contact was in October of 2004 when they were taken on a tour of the property by Mr. Penny. For the Bottoms, they met with Mr. Goldberg in March of 2004, and he discussed the advantages of Oakmont, but did not tell them that, in fact, Superior Homes did not own the property. With respect to Mr. Brown, he went on a tour of the property in 2004 with Steve Ambrose, and he met with Mr. Goldberg, discussed the advantages of Oakmont, and again, although he knew that Superior Homes didn't own the property, he didn't inform anyone of that. Same thing, discussions with Myrna Ambrose. Likewise, the record is that the Shepherds were shown the property by Eric Elbass, who was a salesman that worked under Mr. Goldberg, and that Mr. Elbass and Mr. Goldberg met with those defendants, Mr. and Ms. Shepard, and were told their deposits would be safe. With respect to Duncan Steele and Reagan Selwood, who got judgment against Mr. Steve Ambrose, he took them on a tour in 2004. Mr. and Ms. Tilley went on a tour with Tracy Penny in January of 2004, and then met with Mr. Penny and Mr. Goldberg after that, and both stated their deposits were safe. Now, the Florida Real Estate Commission is going to make probably much of the fact that the economy went south, and it did. There's no question it did. But the original cause for these particular purchasers getting into the contract was that they understood their money would be safe, and they were not told that Superior Homes or any affiliated entity did not own the property. Consequently, they didn't have the opportunity to make a choice with respect to whether or not they would put their money in the contract, not sign the contract, or insist on an escrow deposit. They weren't given that opportunity. While the fact that the economy went south affected the outcome of the contract, It is not a superseding cause. And I can't tell if that's what the Florida Real Estate Commission is arguing. But it's not a superseding cause. It doesn't step completely into the shoes of the fact that, in this case, the parties may not have signed their agreements but for the fact that they thought that Superior Homes was the entity that owned it. As a matter of fact, Superior Homes didn't, the builder didn't, and the builder was going to have to buy from yet a third party. There is absolutely no evidence in the case, in addition, that if they're arguing intervening cause, and it's not clear from what they've argued, that in fact this particular intervening clause was not foreseeable. That is not our burden. That would be the Real Estate Commission's burden to argue. This is what the argument really is all about, and that is whether or not this transaction is a real estate transaction. There's an admission that the judgments were entered into. The only issues being raised by the Florida Real Estate Commission is that this is not a real estate transaction, and these people weren't acting solely in the capacity of real estate licensees. Well, it sure meets the definition of a real estate transaction under Section 415.01 of the Florida statutes, which says that a broker means any person who offers for sale, sells, negotiates real estate or any business opportunity. This was certainly real estate, because if the court will look at 415.01 and some of the other statutes we've cited, 119.001 and 212.001, the statutes have consistently defined real estate to include lots, buildings on lots, improvements on lots, real property. So it's clearly a real estate transaction, but even if we were getting into development with them, it's a business opportunity, and consequently it is covered by by Chapter 475.001. These people are also real estate licensees. So the only evidence in the record is that the only contact that our clients had with these particular real estate licensees were when they were taken on a tour of property. They were acting clearly as real estate licensees when that happened. The fact that there were other things going on with Superior Homes is immaterial. As Commissioner Hornbluth, I think, stated at the commission hearing, real estate agents do an awful lot of things. They show property. They help people get mortgages. But it's all based on the fundamental idea that they're negotiating and attempting to sell and complete a real estate transaction. So in this case, it's clearly a real estate transaction. That's the first issue that's being raised, and the second was, were they solely licensees? We think the evidence is absolutely, without contradiction, that they were only acting as real estate licensees. There is no evidence, the Florida Real Estate Commission didn't put on any evidence, that they were doing anything else but showing property. Then taking the folks to their manager, Mr. Goldberg, to sign contracts. That's what real estate agents do. Even if they took them to look at options, real estate agents do that. And the fact that Superior Homes and its related entities offers title insurance or offers mortgage services also proves that this is a real estate transaction. You wouldn't have those services if it weren't a real estate transaction. So consequently, it is a real estate transaction. We think we've met all of the requirements of 475.482. We have our judgment. The thing that we can't do is we can't get the full amount of our judgments. Our judgments range from 70-something thousand to over 200,000. The deposits range from $28,299 for Ms. Hendricks to $170,000 plus dollars for Mr. Selwood and Mr. Steele.
And you're limited to 50,000.
Yes, ma'am, and we're limited to less than that with respect to Ms. Hendricks.
Right.
Only $28,299, and that's why we're asking the court to remand this case to require that the Florida Real Estate Commission undo its error of law, the way it has defined what a real estate transaction is, and require the entry of a judgment for $28,299 for Ms. Hendricks and $50,000 for each of the other.
Okay, do you wish to reserve the rest of your time?
Yes, sir, thank you.
Okay.
Good morning, may it please the court. My name is Marissa Button, and I represent the appellee in these matters, the Department of Business and Professional Regulation, the Florida Real Estate Commission.
Thank you. Would you outline what these licensees did beyond the scope of acting as, in their capacity as real estate licensees in this case? Just tell us what they did that would prompt the, or that would support the finding that, you know, of the ALJ in this case.
Yes, our position is these individuals, while they were real estate licensees, were employees of the Superior Group, a large entity that had many different arms, including mortgage financing.
Have any ownership in Superior Homes? Were they owners, or were they merely real estate agents that were employed by that company?
They were employees, they were not owners. And so when the appellants referenced, well, they took us on a tour and, made, representations or did not make representations, we don't know, and the appellants haven't established that that was solely in the context of the
They're real estate
license.
brokers, correct?
They're real estate agents, yes, they're sales associates, and they work under the broker who is an owner of the Superior Group.
So ultimately, who at Superior would be responsible? Is your position nobody at Superior?
Our position is, while it's up to the appellants, through their civil action, they actually allege that it was the Superior Group who was responsible for all of this, their owners, their agents. And the reason that they're here is because they couldn't get those underlying civil judgments for the breach of contract with Superior. And when they made the allegations in the underlying complaint against the licensees, they did that in the context of their employment with Superior.
So you're saying that simply because they were employed by Superior, that takes them out of the realm of acting solely within their capacity as licensees in this particular case?
Partially because in this particular case, Superior was not just a brokerage firm. They were the developer of a large, pending subdivision.
That may be true, and they may have worked for Superior, but as it relates to this particular case, what else did they do besides simply being employed by Superior that would lead us to conclude that they acted well beyond the scope of simply real estate licensees in this case?
Well, that's partly what we don't know, because the record hasn't fully established what happened in these cases in the underlying.
Tell us what the record establishes that would lead us to conclude, or the ALJ to conclude that they acted beyond the scope of their licenses.
That they were employees of.
Besides that, I don't buy that argument. Besides that.
We don't have anything in the record that reflects what they did was this in the scope of licensees. They did not sign the purchase agreements with the licensees in this case. The mere allegation that they took these individuals on a tour through a default judgment.
For them, the contracts would not have been signed, right?
No, that's not our position. And their position is Superior Group marketed, the entity Superior Group marketed those appellants out of the country in the UK through their UK arm to come here and take tours of the property.
Just to make sure, so you're blaming because Superior marketed this, that they're the ones that are responsible, and therefore these people acted, they were not acting solely within their capacity as real estate licensees.
Yes.
So the only thing that you can point to is the fact that they were employed by Superior, right?
That they were employed by Superior, and while I understand Your Honor may not accept the argument, that Superior had many different arms of which they took a part in.
About this particular case, what did and the only thing you can point to in this particular case was the fact that they worked for Superior. They were employed.
Yes, they were agents of Superior, not independent third-party real estate licensees.
Transaction?
We don't have any dispute about real estate transaction, and our position is it's a development deal. Our position here is, number one, there were no established violations violations of Chapter 475 by these licensees that resulted in the loss of their deposits.
It was, the claim stemmed from a real estate brokerage transaction, correct? And the licensees, or these employees of Superior, acted as, in their capacities as real estate agents, correct?
Well, we don't, that in addition to other things that they may or may not have done.
This particular case, though, they showed the people around,
They show, yes, if we take all the allegations in the complaint as true, yes.
they brokered the deal.
And they did not, well, we don't know that they brokered the deal. We know that they're taking the allegations in the complaint as true, that they took the appellants on tours of the properties, and ultimately, if we refer back to some of the deposition testimony of Mr. Goldberg that occurred after the default judgment, that reflects that they did many other things as well, because basically, he's saying they hand this off to the folks inside it to broker the deal at Superior. So their names are on the contracts, but they're not signed.
A judgment was obtained against them, correct?
Absolutely, there's no dispute there was a default judgment, but our position is the facts underlying that default judgment do not rise to disciplinary violations of Chapter 475.
Well, this isn't a disciplinary action against those agents. This is not a disciplinary action. This is a remedial statute for the homeowners to be reimbursed to the extent the statute allows, based on their losses in this real estate deal, based on the misrepresentations that the judgment indicated.
It is true that this is a remedial statute, but there's an underlying penal nature to that statute.
There is no penal, the penal nature comes after the fact. And I know you argue that the standard is clear and convincing, but I don't buy it. What happens to these real estate agents as a result of what may happen with regard to whether there is a reimbursement to the people by FREC, that is separate and distinct. That the penal aspect is separate and distinct. In terms of what we're dealing with here is remedial. And the standard of proof is going to be a preponderance standard in that particular aspect. I mean, we're not dealing with a penal statute with regard to the real estate agents. Now, something may happen as a result, but that's a different proceeding, not this one.
The legislature has required that something happen as a result. The FREC shall immediately suspend those licenses. So
Well, that happens, that's a result that is in a different, separate proceeding. It has absolutely nothing to do with whether or not the individuals that come in this case prove their case or not. It's not penal against them, it's not penal against FREC.
And even if we were to take the preponderance of the evidence standard, as Your Honor references, as what's required to be proven here by the appellants, our position is still that they don't meet that burden. The commission has a duty by the legislature to opine on practice standards and ultimately make these determinations. And if we have a blanket default judgment entered by the circuit court, that essentially eviscerates the commission's position to review whether or not there was a violation of Chapter 475. And their position was there was not a violation because they couldn't establish that there was a misrepresentation in the underlying case.
We have a judgment, and the judgment says there was a misrepresentation.
The judgment, the facts, we have to look at it's our position, we have to look at the facts, and the commission's position that they have to look at the facts underlying the judgment.
Says they knew or should have known that the title was not held. So why isn't that sufficient?
Well, as the commission deliberated this, they said there's no requirement that a real estate licensee investigate the title to the property. And so they don't have that independent...
They're taking them out and showing them property, knowing that these people are interested in buying it, and they knew or should have known that the title wasn't held by the purported seller. You don't think they have an obligation to tell them that, and that if they don't, that's fraudulent concealment?
Your Honor, there was no duty upon these licensees to investigate title beforehand. In any...
It's the judgment says they knew or should have known. Is that a finding?
That's not, there was no allegations in the complaint that would have resulted in that finding.
What does the judgment say? Does the judgment say they knew or should have known?
Yes, Your Honor, the judgment says they knew or should have known.
So we have to take that finding in the judgment, because I don't see anything that disputes it. And so if that's what the judgment says, they knew or should have known that the title was not held by the purported seller, and they did not reveal that, why isn't that fraud?
Our position is that we do have this, this judgment that was entered by default that these folks
What
didn't
did it appeal?
defend.
What difference
appeal?
does that make?
The difference that makes is that the commission still has the ability.
You could have gone back and you could have attacked the finding and asked for a motion for rehearing and gotten all that cleared up. Instead, we have a judgment that comes to us clothed with the presumption of correctness that says that they knew or should have known. And we have to deal with that, and we have to accept it. And if that's the case, I'm asking you, if they knew or should have known that the purported seller did not have own title, did they have a duty to disclose that? And if they didn't, why isn't that fraud?
They did not have a duty to disclose that. In 475, the only requirements upon the licensee is that they are in violation of the statute if they materially misrepresent that the owner has good and marketable title. And that's,
A material misrepresentation can act by omission or commission. And if you remain silent knowing that you've misled these people by your actions and showing them property, that they think that they're going to buy from the purported seller that the real estate licensee knows doesn't even have title. You're telling me that's not a misrepresentation?
no, because there is not a knew or should have known aspect to that part of
Well, the
475.
part of the judgment, just as to each of the judgments, that the individuals, and it talks, 1A, knew or in the exercise of reasonable care should have known the representations made were not accurate. It goes on, and B, those intentional misrepresentations of material fact constituted a material inducement to execute the purchase agreements.
And our position is that doesn't result in a violation of 475 that is the purpose of recovery in this case.
So you're saying that the only way they can recover is for them to say, okay, the seller has title and we're going to make sure that it's conveyed to you and that there will not be any problem, rather than them knowing that and just not saying anything about it?
There is nothing established in the record that reflects these licensees knew. They did, and the commission took that under consideration and said that's...
I just asked you about the judgment. We have to take the findings in the judgment as being correct, and the judgment says they knew or should have known. That they knew or should have known.
And our position is the commission does not have to take that default judgment as a per se violation of Chapter 475. They need to look at the facts underlying the judgment. So that's the difference. The commission has the regulatory authority over this to make that determination. And in this case, in their deliberations, they determined that there was not a duty to disclose. That these employees, it was fair for them to make a good faith assumption that Superior owned the property. And furthermore, that the buyers had the requirement under the purchase agreements to go through their own title search just like any other real estate purchaser would. And that didn't, and we didn't even get to that point in this case, but fundamentally the commission said, we don't have to take this final default judgment as just a per se violation of Chapter 475. We look at the facts underlying, and the commission determined there wasn't enough to establish that there was that violation.
The judgment has said that they knew, not that they should have known, that they knew that the purported seller did not have title.
I think that
What if the judgment said they told, knowing that it was false, they told the buyers that there was that the seller did have title and that they would be able to convey good and marketable title, and they told them that. Are you saying the judgment says that? Are you saying that even in that situation that the ALJ has a right to go beyond the findings in that judgment and say the judgment's wrong?
I'm saying that the commission has the ability to look at the facts underlying that judgment, and if the facts underlying the judgment support what Your Honor has referenced, certainly they can make that finding.
What does the judgment mean then?
The judgment is, the judgment,
What effect does it have on that? Is it meaningless, or what is it?
it's not meaningless, it gets their foot in the door, but it doesn't, it's not the end-all be-all as to whether or not there was a violation of Chapter 475. Otherwise, the commission wouldn't make the determination. The commission made the determination. This went before an informal hearing in front of the commission where they made that determination.
So you have a judgment that says one thing, and then you have the ALJ that says something else, and so we're supposed to go with the ALJ.
Well, we're supposed to go with the commission because the commission is the entity that the legislature has designated to deal with these very specific industry-related issues. And so, yes, we do defer absolutely to the commission because they have the agency deference and expertise in real estate transactions. And if we look at the record in their deliberations when they talked about these issues, they went through that process and they ultimately determined, based on their review of the entire record of the proceedings, that it didn't meet the standard for recovery.
Okay, you have anything else?
Unless there are any other questions, no, we'll just ask that the court affirm the decision of the commission. Thank you.
May it please the court, I don't think I have very much to add to the conversation that's been on here. The bottom line here would be that we couldn't get a default judgment. We would have to take every case in which a defendant doesn't answer to
Opposing
trial.
counsel says that the ALJ and the commission have every right to bypass that and make their own findings and determinations and say that what the default judgment says is wrong.
Your Honor, they never brought that up in front of the commission. This is new, and all the evidence based on our consolidated request was that we've got a default judgment, the default judgment that says that they knew or should have known. It seems to me like the primary finding was that these licensees did not act solely in their capacity as licensees. That was one of the primary findings, and it wasn't a real estate transaction, and then they arguing that it doesn't qualify for reimbursement because there wasn't any wrongdoing on their part. And then they say that they have the right to, just disregard what the judgment says and look at the evidence and testimony themselves. So we'll look at it and see. Thank you, Judge.
Do you have anything else you want to please have a little extra time?
No, sir, I agree that the standard is preponderance. I think that the evidence is overwhelming that they committed a fraud by omitting a material fact.
Okay, thank you. Thank you both very much. Take care.